For delivery of judgment, WPC 652/2018.
With regard to that inquiry and criminal cases, we have said no further inquiry because the criminal cases have come to an end. You are at liberty to pursue your remedy. With regard to the compensation, we have said that you have claimed for 2 dead persons and 3 seriously injured. Yes, for the death victims, it will be 3 lakhs. And for the injured victims, 3 persons whom you have identified, it will be 2 lakhs each. And this is in addition to what the government has. And we have even given you liberty to proceed before the Court of Civil Jurisdiction for further damages. Deeply operations. You will get the order tomorrow. There is some corrections. We'll do it today, tomorrow. Gotcha.
Please. Well, I am paying for a short accommodation for today, but I am not keeping well. Item 42 and 43. Can it be one of that one for today? Any day, your lordship's convenience for it. 42, 43.
42, 43.
Well,
You have with you a foreigner with a name as foreign.
I understand well.
Okay.
Correct.
42, 43. Separate orders. Both sides are represented on the prayer made by non-counsel for the applicant. In 42 and 43, it will be petitioner. The matter stands adjourned today. Oh no, applicant in both the cases. Stands adjourned today. This dot. Due date after 2 weeks.
Deeply.
Yes, so may I pray for listing of the habeas corpus of petition and also tomorrow. We have challenged an NSA order. Yes, sir. Item number 39, your lordship. So admission column, your lordship. I am not in India, your lordship. Personal mail update.
We'll try to.
39.
Okay.
Hello.
Lordship, item number 11 and 25. Mayor, I request for a short adjournment. The Judicial Council is not.
11, you will have to wait because it's 2018 matter. Before item till 21, we are not adjourning like that. Second item is item number
25.
25. This is also 19. You will have to wait till the matter is called.
Please, Your Lordship. Lordship, I beg to mention item number 20. Lordship, this matter has been wrongly listed before this bench. 20.
Let us see this item 20. Let us see item 20. 20. Item 20, 20. Yes.
I may be allowed to go through the report of item number 5 and 6.
Lordship, kindly, it may be listed on Friday. Before
Just wait, let us see the records. Miss,
NM Longke.
just write it down. The counsel for the petitioner submits that the matter relates to recovery of excess amount paid to the petitioner on account of wrong fixation of the. Accordingly, comment is submitted that the matter is required to be taken up by the single bench of this court. Next point. The matter stands adjourned today. Let the matter be examined by the registry and list the matter of before the appropriate bench on, you want it Friday? 28/8/2026. The order be brought to the notice of the registrar.
Nice lordship.
Motion, item 1 with item 2.
May I please, Your Lord? Same time.
Okay. You take it up in the admission column. Or this is 18 matter.
My lord, in this, both this case, my lord, in one case, item number 1, it is shown that TCR is there. In item number 1, TCR is seen to be there.
What cases TCRs are there?
Another, in item number 2, it is not reflected in court list.
Oh, that's okay, but it has come. Both have come. Past separate orders, both sides are represented. Pursuant to order passed by this court, the records of the tribunal is received. Accordingly, court is inclined to issue rule returnable. Receipt, which requires examination. Next para. Issue rule returnable forfeit without requiring any steps to be taken. List the hearing column. The week commencing due date after 2 weeks. You have a copy of the writ petition with you?
Yes, sir.
Your Lordship, I may be, there is an earlier order that until further orders, the proceeding may not be arrested or deported. So that may be continued, if Your Lordship may please. The earlier order.
Now you want it to be limited to next date.
Till further orders. Nice one.
Item 3.
My lord, due to my personal problem, my lord, I was out of session, my lord, so my lord, I could not prepare the matter. My lord, kindly, heard on Friday, my lord.
Not early, we'll take it up on Monday, 31st August.
Okay, my lord.
List on both sides are represented. List on. (41/8/2026) as paid for by Land Council to the petitioner.
small prayer kindly allow me to see the TCR.
You go for it.
Most of all.
Item 4,
No, no, go. So in this case, the petition is not, they will require your inputs on the TCR, because here the opinion was passed because the name of the grandfather is changing and the shifting has not been explained. So you have to go through the exhibits and their addresses. We'll take it up in the admission column. Non-abusive call for the petitioner, how all the response. Huh? No, ARB is not the council on record. With AR Sidhar and Ahmed and SI Talukdar, they are on record. Non-accusing call for the petitioner, all the respondents are represented. In view of the projection made in the petition, the court is inclined to issue notice returnable on so and so, list in the admission column on so and so.
item 5,
No, records are not available.
Last order left. The records of one case number 596.
Just look at this order. Last order.
Tomorrow or day after tomorrow, madam. At 2 minutes, I will be. Day after tomorrow.
Notices are represented. The bank and its standing cost for the border and FT matters. Promise that he requires to verify from his records as to the availability of the records of the case referred to in the last order. As per accordingly, matters stands adjourned today, just on day after tomorrow. 28.
Item 6.
The this year has been dismissed, my lord. But let the matter be take for admission hearing, my lord.
You've given a copy of the repetition.
Yes. Yes.
Last time you were required to give him a copy of repetition.
Okay.
Both sides are represented. Pursuant to order passed earlier, the records of the cabinet is received. Which requires examination. Expect on the issue notice. Should not determinable regarding any steps to be taken. Next, further, list the matter in the hearing column in the week commencing. No date for the hearing. Week commencing.
Item 7.
May the matter be passed over for the time being. Ms. New is only left from another code.
That's fine.
Yes. Yes, well, actually, in this case, the petitioner should not have appeared because notice was sent in the name of another person, kindly see page 46. But I do not know why she appeared page 46, kindly say 46. It is in the name of Saleha Khatun, wife of Hafizuddin, village Borpeta, PS to Bulihat. It is you are different. So it has been issued in the name of Saleha Khatun. I am not Saleha Khatun. I am Sulema Khatun, alias, that is Sulema Khatun. So documents or name in the name, alias, it is given by mistakenly by the lawyer. Actually, it should be Sulema Khatun. However, as she appeared, she produced the document which are available with him by the name Sulema Khatun. Now, Sulema Khatun, Lordship, we can see page 14. Page 14 is a document in the name of my grandfather, Abdul Aziz Sarkar. It is dated 15/3/55. Exhibit 3.
Just a moment. Just a moment. Which page is your written statement?
WS page 48.
Your name appeared in the voters list for the first time
Yes.
in 1997.
Yes, with my husband.
Which page is that?
That is page 34. If you have the Lordship, may kindly see page 32.
Yes.
Page 32, kindly see. This is in the name of Azmat Ali, 2019 voter list. Azmat Ali is my father. And Zamir Ali is my own brother. And this Zamir Ali has adduced his evidence as DW3, which is page 32. page 32. And my father's name is Azmat Ali. His name appears in the NRC 1951, page 17. Then Lordship would say, page 19. That is the voter details in the name of Azmat Ali, page 19, answer 3. And it is marked as Exhibit 1. Then voter list of 1965, page 21. It is in the name of my father, Azmat Ali, page 21. But unfortunately, it is not exhibited because in the what is they have legacy data they have exhibited legacy data. Voter list that has been treated as voter list, that is exhibit 2. 65 voter list is the exhibit 2. Page 67. Yes. Sorry, my lord, exhibit 65, voter 65, exhibit 1. 70 is exhibit 2.
Yes.
So this exhibit 1 is the voter list of 65 in the name of my father. Exhibit 3 is the cell deed dated 15/3/55 in the name of my grandfather. Then exhibit 2 is the voter list of 1970 in the name of my father, Azmat Ali. Then Lordship would see Exhibit 4, that is the Jamabandi in the name of father, dated 16/9/99, page 25.
Exhibit 3's page.
Exhibit 3 is page 14. Now kindly see the Gauhati certificate, Exhibit 5, page 44. Page 44.
Yes, please continue.
Page 44 is the certificate issued by Gauhati of my village, and by my birthplace.
Yes.
Gauhati certifies that this is what is most important link test document. That Sulama Khatun is the daughter of Muhammad Azmat Ali, inhabitant of village Borpeta, Mauza Saidaria, post office Raumari, PS Rukuhi Hat, district Naga Assam. The above mentioned person is a resident of Borpeta village. He is known to me very well. I wish her every success in life. Now, this Gauhati is the DW2, page 44.
Yes.
DW, so Gaura's, no, Gaura's evidence is page 58. Certificate is page 44, but his evidence is 58.
Yes. Yes, please continue.
Yes, now, case 58 is the Gaura's evidence. I am the government Gaura of village Borpeta. I received notice from this court. I am government Gaura since 2009. Prior to my father was the Gaura of this village. I know the opposite party Sulema Khatun, daughter of late Azmat Ali. She was born and brought up at village Borpeta and got married to the same village with Mofizuddin. At present, she resides at her father's home after her husband's death. I have seen the office since her childhood. Office actual and correct name is Sulema Khatun. Office mother's name is Mosammad Jorina Khatun. She cast both till death. Office has three
Mr. Mahmood, your case in your evidence is horrible. But Mr. Payang, the witness has faltered everywhere. The evidence of the three witnesses do not match. There are many inconsistencies, but what we find is from the record that
there is no PP value.
that the sale deed is of 1955, which is in original. The name of the father has been mutated, but the witness has not been mutated. DW3. The So if you can come to page 35 of the, sorry, this is page 26. Then you find, you don't have a copy. Mr. Mahmood, give him a copy. This is Jamabandi. Last Umma is that entry, Chakra Bikha Moda, Ivan Tarikha. Name of the father is mutated. But the evidence is horrible. If you go by the evidence, then the petitioner has no case because she does not know the name of the village of the husband, does not know the how many brothers and sisters she has. So she is not a good witness. the comparative reading of DW1, DW2 and DW3 damages the entire case. But nevertheless, the documents are in the favor of the petitioner. That is the sale deed, which is at of 55, which is at page 14. This in the traveller's record is in original. In the name of the grandfather, this is exhibit 3 of 15355. And then comes the what is this of 65 and 70 of Azmat Ali. Page 26 is Jawabandi exhibit 4 Azmat Ali. But she says in evidence that the name has not been, DW3 says name has not been mutated. So they are giving evidence contrary to the record.
What my understanding is, well, what my submission may be, but the person who has been prosecuted, who has been proceeded, probably she is not that person whom they are trying to protect.
No, but you see, the original, the original what you call sale deed
Yes,
would not be parted with.
but that is their money.
You can help your colleague with everything,
No,
but will not give him.
I'm not saying that original sale deed is not there. Original sale deed is there. Azmat Ali may be son of that person. There is no doubt on that. Now, only to link, whether Sulema Khatun is the daughter of that Azmat Ali or not. And whether this Sulema Khatun is the granddaughter of that person whose name was there in 1955.
No, that link is there.
Yes, that link is otherwise, I'm not unbelieving that
That link is there.
held it and the
But
petitioner.
they have not been able to
Link the petitioner along with the projected grandfather or father. That is the only,
when we have a learned lawyer,
because she has missed everywhere.
she has missed everywhere.
Yes, she has said.
Missed everywhere. Had we
So
not,
she is not the, if I may not submit it, but she is not the daughter whom they are trying to say this is
no, she does not know.
Yes,
She does not know anything.
yes, she does not know anything.
She does not, she's
She
not a
is
good.
just trying to project all those documents belong to her father.
No, but we had asked about this.
One point is this, color. All the three witnesses have been cross-examined.
No, your witness is horrible. If you go by the witness, then you are a foreigner.
So I
They can't
understand,
save you anyway.
but there are no
It
people,
is-
but
It is
process are
better,
there.
it is better if you don't speak.
Yes. He sure not properly.
Once you make that statement, then we are bound to take notice of what Mr. Bayang is saying. Because you see, once we go to the evidence, then you have to dismiss your petition. There is a discrepancy, huge discrepancy, which can't be overlooked. Number one, you in your evidence say that you have one brother. Your Gauhati comes and says that you have three brothers. You don't know the name of the husband's village where you got married. Therefore, when Mr. Payang is saying that you are a person who has been trying to substitute someone, there is a good ground. That is why we are asking you not to persist in your argument.
Well,
That will lead you to dismissal. The other ground which Mr. Payang would take is that whether in certiorari jurisdiction we can evaluate the documents. The answer the Supreme Court says is no. So you stand at a very disadvantageous point.
after all, my lord, the Honorable Court has the power equity, law and justice in that view.
Not in certiorari. We have our limitations. It's a chained freedom. We have to act within the boundaries of the certiorari jurisdiction. The substitution of the allegation of Mr. Payang that somebody is substituting as the daughter of daughter and granddaughter of the projected parents is very true, because in your evidence you say that you don't even know how many brothers your father has. This will happen only if you are not the daughter. People who are in village will not know the name of the brothers of the father. It's something very strange. Not knowing the husband, the village of the husband is more strange. It's not acceptable at all.
But the woman person may kindly consider.
Yes, but document doesn't help if your evidence is otherwise.
Yes.
You show us any law where it has been held that if the documents and the evidence is in variance, the documents will prevail.
We are not properly tutored by the learned counsel to conduct the case.
Tutoring should not be there. It's nothing. If you ask me what is the name of my father, I don't have to look at my sister and then answer what is the name of my father. It's not tutoring. Tutoring would be if I look at my sister and then answer who is my father.
Yes.
The only fact which is bothering us is your original sale date. You have a very good brother. He comes and says that even after exhibiting a mutation Javandi, he says that name of my father is not mutated. Then who's your father? If the witness comes and says that my name is not mutated, he's exhibiting the Javandi, then who is your father?
I may not be the same person, but whose name is
Correct.
mutated.
Your other was right. I don't disagree. You are absolutely right. You have rightly caught the what is the proverb? Bull by the horn. That is true, absolutely true. But what is weighing before us is that original document. Just have a look at that. Since I am trained to look at the documents in a civil side, the sale deed, Javandi, and the name in the voters list makes a connect.
And that's it.
Yeah, in the quality of evidence, my lord, I think there is many drawbacks. But I
No,
pray that
the very good thing is that the learned counsel in this court who are well acquainted with evidence, they don't go spend time with the district bar. They are not doing that. More than the members of the bar, I am moving around in various district bars and interacting with the lawyers on evidence.
2-3 times we tried, my lord, but many lawyers do not cooperate. That is the problem.
That is why we said it's a good thing. That the bar does not want to upgrade itself. It's a very good thing.
Instead of calling the clients to their house, in court they take the brief. So carelessly they take it, and that's why this
No,
is
we
like,
won't comment. It is not for us to comment.
That this document is exhibited as exhibit 2. It's not produced by the Malati, not brought by the proceeding. It is by the Gauhati who brought this petition. It's the Gauhati who brought this petition. So she is not the custodian of the document.
So,
It is PW3 Malak, Fakul Islam, who has exhibited this document.
exhibit 2.
Exhibit 1, 2, and 3. This exhibit 4.
Oh, yes, you are right.
So he is not the custodian of the document.
Oh.
those are in my name, not in Gaura's name. So very negligently case has been conducted. My humble prayer is whether not the matter may kindly be remanded, give me a chance to.
No, because there is no evidence at all. If that can't be cured, even if we want to, we can't cure that effect. Oh, it has not been produced by the petitioner,
Not by the petition,
by the Gauhati,
by the government. Jamabandi?
Jamati by the brother. Oh, no, by Gauhati.
Gauhati.
Exhibit 4.
Exhibit
48.
Not actually, she has said that I have some documents, but she has not exhibited. But she has said that I am reading for a moment.
No, then you realize the gravity of the statement which you are making. We were thinking that this 55 tail deed was produced by the petitioner. And therefore, if the petitioner does not produce the documents, any fault, then he and the witnesses falter on the village of the husband, the brothers, sisters. That is very fatal. That means Mr. Payang is right. Somebody is being substituted.
It may be a presumption, but for that matter, I lost vision that a report may be also called for in the interest of justice.
No.
From the SP.
No, we are not creating any evidence at this stage in the repetition.
She has said that I have documents. I casted by my father's. I cannot remember how many brothers. I did not.
No, how many
Yes.
brothers your father has?
I cannot remember how many brothers. It is only.
No, that is wrong.
That is here.
That is the error
Here
in
is
your,
full stop.
that is the error in your,
No, it is syllabus evidence. Here full stop is I cannot remember how many brothers. I did not study in school. I am not foreigner. Then my father has landed property and submitted land documents. Amjad Ali is my father.
so that is your typing error. In the handwritten, it is at page 56. It is my father has or not, comma, I cannot remember how many brothers. It's a comma, not a full stop.
My father has.
Well, there are so many locals that I can. But only
No, but that is why that is why the Gauhati has to produce documents. She is not the actual daughter. Otherwise, it's very strange that a lady would not remember the name of the father's brothers. It is very strange. We were overcoming all this because of the fact that 55 voters with the still it is there. But now everything is turned. Brother comes and says that the name of the father is not mutated. Everything is now heavily against you.
yeah, my lord, I have two submissions, my lord. First one is this, that perhaps the lawyer took when she was found so ignorant and illiterate, perhaps he told the governor that you may exhibit the documents. Maybe it is on presumption subject to correction. Second thing is this, my lord. There are cross examinations of all the witnesses, 3 witnesses, but there is no PP. And I remember your lordship in many cases. This honorable bench has remanded the case on the ground that there was no PP, but there were cross examination. So these are the only 2 points which lordship may consider and give me a chance. Your lordship has already understood how much illiterate, how much ignorant I am.
Okay, we'll examine the records and we'll take it up at 2 o'clock. During lunchtime, we'll look at the records and then take it again at 2 o'clock.
Lord, yeah, my lord. Item 23 and 46. When one day decide 2 or 3 cases difficult.
No, you have to wait 2000 cases, 2018, it's more than 9 years old. You have to wait.
I do one case without fail. If I am available.
You'll have to wait. It's 2017 matter. We are not recording without looking at the records.
Item 8.
Learning Council had reported to the court that the file has been taken away by the son of the petitioner, namely Wajid Ali. And on the last occasion, we requested you to find out if the petitioner is still in detention camp or he has been sent back. You see this order?
Those persons who were detained prior to 2019, even those who have been released during
Mhm.
COVID period. Those persons who were detained prior to 2019,
Okay.
all those persons were released during COVID period.
During
As per
COVID
the
period.
direction of this number,
But-
resolution number expert. So I may get instruction by whether he has been detained or not.
Yes.
If
We'll take it up day after tomorrow.
yes, wait. And if necessary, my lord, because amicus curiae may be otherwise there will be unrepresentative.
Hmm?
You know, lots may appoint amicus curiae also if necessary.
No, it doesn't help because there is nothing on record. This was perhaps proceeded ex parte and there is an opinion. There's nothing.
No, here in High Court matter, because they have withdrawn the Pakalandam of.
No, we understand, but it can't be helped. The reason is that even if we appoint
Yes.
anyone as an amicus curiae, there must be some material here to argue.
Yes,
Otherwise, the amicus curiae will not get any instructions.
yes.
If-
Let me get.
If the petitioner cannot be found in the detention center,
Yes,
we can't even ask the amicus curiae to interact with the
yes.
person through the SP and then
Yes,
the transit camp.
Yes,
So the
23.
council will not, amicus curiae will not know anything
Yes.
except standing
Yeah.
because they have been appointed by the court. That's
Okay, I'll get the instruction.
you see, none appears on call for the petitioner. So the petitioner was unrepresented when the matter was previously listed. It's on the last date. That's correct. All the respondents are represented. Next paragraph. Make clear that if the petitioner remains absent on the next date of listing, comma, adverse orders will follow. List on 28(8). Next. Last.
Item 9.
Yeah, it will work. Actually, formal notice has not been issued to the lordship, so or it has come to the national law. What I mean is, lordship, issue. Yes. And another last order is to Mr. Lordship. Here another inquiry was supposed to be done by the SP Lordship.
Previous to that, the order was that you wanted some time to look at the records and then argue the matter.
Yes, Lordship, that's all. Last order, Lordship, has given this direction to hand out this, and next.
What is the name of your father?
Authorized Ajay Dalil. So Ajay Dalil, this is the two screen lordship. Ajay.
The other part, the record the tablet is received from as example. So notice returnable consequence. Just in the admission column also.
Implemented functional lordship.
Interim past tense is extended to the next statement. Okay, step.
Follow.
Item 10,
Leave the lordship. Lordship, in this case, Lordship petitioner declare foreigner to stop 71 Lordship. Including opinion is page 64 to 68. Lord. Please stand on. Please stand on.
Your name did not appear in any voter list.
My lord, in the year of 1980, my lord, petition name has been appeared in the voter list, my lord.
89.
Yes, my lord. '89, my lord, sorry.
Hmm?
That is page 20, my lord.
Fifty nine is not an exhibited document, so there's no link.
Exhibit 5, my lord. Exhibit document, my lord. Johor Ali. Petitioner name.
5.
Exhibit number 5, my lord. Oh,
No,
exhibit foreigner.
no, that's not an exhibited document.
No. Exhibit 1, 2, and 3.
1, 2, 3, 4. 4 documents are exhibited. The exhibited documents are after page 51 of the PCR. You're not exhibited the document. Here. That's. In 2017, you disclose your age as 62. That means you will be born in 1955. You got the right of preference at the age of 18, 1973. 73 to 89. Don't have anything to show that you are in the country.
Yes, Lord. Exhibit for another but they have submitted the document, my lord, in the total list of 1918 of my lord.
We have given you the forwarding letter, only 4 exhibits.
Yes.
4 exhibits are mentioned in your evidence. Exhibit 5 is not signed.
Not signed by the tribunal member.
Because you did not exhibit it.
But in the total list, there is a written the exhibit number so my lord.
No, I understand.
Yes.
You can have a book and then in 500 pages you can write exhibit. Doesn't make it an exhibited document.
No. To submit the original document before this tribunal.
In evidence it is not there. Till now we had heard about extrajudicial confession. Now we have extrajudicial evidence.
Not, in the year of 1965, the petitioner father name has been appeared in the Hussain. But as is not mentioned in the total list. Janapra Mailot in the voter list of 1971. Ali Hussein and Aburan Nessa, father and mother name has been appeared in the voter list.
Mr. Sharma, look at what is exhibit 6 in that document that this we are doing. The voter list of
Jamabandi, but it was
65. Do we have a 1965 voter list there?
1965 lordship, father voter list. Yes, lordship, this is
Whose name?
exhibit 7.
Whose name?
Aziz, Hussein Ali, Rahimdin, Sirajuddin, Solomon Nessa. And Hussein Ali's name appeared lordship projected father, but in WS he pleaded that his father's name is Ali Hussein.
But it's not mentioned Hussein Ali and Ali Hussein Ballot Simon on that.
But
That is okay, interchangeably used. Doesn't
Ali and Hussein.
thing. The pleadings and in the evidence, there is nothing. There's again a flaw in your evidence. Even 4 exhibits are not there. 4th is generated by the court itself, the tribunal. Come to page 38. Exhibit 1 is so and so, exhibit 2 is so and so, exhibit 3 is so and so. And again, number 4, exhibit number is not given.
Exhibit for loan deed.
It's 38.
Exhibit for loan deed of date 24/11/1958. Which
Exhibit is not stated.
that is my in evidence it was not stated, but lordship in page here. This page 51 of the LCR lordship.
What is it?
The D4 of the.
No, we understand, but it is not there in the evidence.
Yes,
It is not there in the evidence, but the tribunal signed it
yes, lordship.
as exhibit 4. Although it was not exhibited by the petitioner. Sorry, we don't have anything. Even the Gauhati certificate goes. This is a matter we have to dismiss the petition. Please send the record for once. We have to look at the order dated 7/11, order dated 7/11/16. Sharma, it appears that we are taking more trouble than anybody else. Neither the tribunal nor Mr. Hassan, nobody has time except us to look into the record. Not even the tribunal. The tribunal also does not have time to look into the records. We are the only two, in simple words, two people have no work to look, no work but to look at the records. It's very sad. This, you have to do something about it, Mr. Das. No, just. Mr. Hassan is a good person. He has saved some money by spending less ink while typing. Look at order dated 14/5. Read that order, 14/5. We have given a flag. 14/5/18. Please read the order. So please read, we can't hear because we'll miss out something.
নথি পেশ কৰিছে প্ৰতিপক্ষই নিযুক্তি বিজ্ঞ অধিবক্তাৰ জৰিয়তে হাজিৰ হয় আৰু তিনিজন সাক্ষীৰ শপতনামাৰ ওপৰত সোধপোছ কৰাৰ অন্তত যাবলৈ দিয়া হয়। নথিত দেখা যায় প্ৰথমজন সাক্ষীৰ শপতনামাৰ ওপৰত সোধপোছ কৰা হোৱা নাই। ধাৰ্য 4/6/18 2 নং সাক্ষীৰ সোধপোছৰ বাবে
Three witnesses were examined, cross-examined.
Yes, Doctor.
Correct. But the presence of the APP is not there.
Yes.
Correct.
নতুন প্ৰতিপক্ষ নিযুক্তি জৰিয়তে হাজিৰ হয় আৰু তিনিজন yes, Doctor. Okay.
Correct. Now come to the repetition, page 40.
Okay.
Please at this page 40, where Mr. Hassan has saved some money. Correct. Now turn over to page 41. In the middle, you will find Pradhakok pass. So this Pradhakok pass is not typed in the main case. So when we were reading the English translation, we did not get it. So therefore we read the SMS one. Then we found exhibit 5. That exhibit 5 is in that record. Now you'll have to read order dated 7/11/16.
Okay.
7/16,
Yes, Doctor.
the advocate files documents.
If proceeding is present and prays for another date as copy W number 2 is unable to attend today due to NRC duty, in considering the prayer of the petition number mentioned next date is fixed on 20 to 12/16 for cross examination. The certified copy of the voter list of 1989 of 85 Rubuhia, Assam, filed today by the proceeding is kept in the record and none appears for the state.
Yes. So although that is not there, then this witness has been cross-examined in as well as the exhibit 5 was mentioned.
Mm.
Now, in the opinion, you will find that this exhibit 5 is not referred. And page 66, the tribunal records, the proceeding submitted another certified copies of so-and-so which are not exhibited. So that leads to perversity.
Yes, Lord.
Although there is no case, but we can't do anything. Page 66, exhibit 1, 2, 3, 4. So that means the tribunal does not even read the cross-examination. And had we not read the Sassanese version, we would have missed it. Why you can't read the brief? Why you can't read the documents and type it? It's not excusable. You look at the amount of effort we are giving. We are saying that we have no case, and then still we are reading the records. We have told you half an hour back that you have no case. Even after that, we are looking at the records because we should not miss anything. We have no duty to do it. You will have to assist us. Why should we look at the record? Why should we examine things and then find out fault with the orders of the tribunal if you don't do that exercise? You have to assist us. You have taken the fees. You have to make your submissions to the court. If you don't assist us, blunders would happen. We would have declared him to be a foreigner. Although he has no case at all. Still, the tribunal will have to rectify the records. Excusable that. What happened if we were like you? Nonchalant, uninterested in the records. What would have happened? Every time we have to find fault with the record. We are remanding the matter back. Third, Mr. F.A.S.N. and counsel for the petitioner and so and so for the respondents. Next question. By filing this petition under Article 226 of the Constitution of India, the petitioner, namely so and so, has assailed the opinion dated page 64, dated 24/9/2018, passed by so and so in case number so and so, police reference number so and so, by which the petitioner was declared to be a foreigner of post 25/3/1971 stream. Next column. In view of the order of remand that the court is proposing to pass, this order is not burdened with the discussion on the pleadings and evidence on record. It would suffice to mention that as per the tribunal's records, the petitioner had exhibited 6 documents, being number 1, certificate of the Gambura dated 2/7/2015, within bracket exhibit 1, electoral roll of 19 certified copy of electoral roll of 1965 within bracket exhibit 2, certified copy of electoral roll of 1971 within bracket exhibit 3, certified copy of sale deed registered on 24/11/1948. was obtained on 4/5/1967 within bracket Exhibit 4. So the reference to the said exhibits is found in the evidence on affidavit filed, not post up, however, comma, in the evidence on affidavit filed by the petitioner as OPW1, comma, the same contains reference to only 3 exhibited documents, being Exhibit 1, comma, Exhibit 2, and Exhibit 3. However, Exhibit 4 bears the signature of the learned member, comma, Foreigners Tribunal number 4th. Full stop. The OPW1, the examination in chief of OPW1 was recorded on 14/5/2018, and it is examination in chief, comma, the petitioner had referred to Exhibit 5, comma, being a sale deed which was in respect of land which was sold off. The type copy of the examination in chief and the cross examination of the petitioner, comma, recorded on 14/5/2018 does not contain the reference to Exhibit 5, comma, but on perusal of the records, while the deposition recorded in Assamese contains reference to Exhibit 5. Next. In the on a perusal of the records, it appears that the OPW number 3, namely Safar SAFAR, Safar Ali, had not referred to any exhibits in his evidence on affidavit. However, the learned tribunal proceeded to record the evidence in chief of the OPW 3 on 14/5/2018, where he had stated that the land of exhibit 6, which was exhibited, has been sold. Therefore, the travels records reveal 6 exhibits of the petitioner. However, in the impugn opinion dated 29/4/2018, the learned tribunal has referred to only 4 exhibits, and it has been specifically mentioned that mentioned to the effect that the petitioner had submitted other 3 numbers of certified copy of voter list of 1989 and 1965, which were not exhibited. The document which is available on record and marked as exhibit 6 there's exhibit you see that in the records, the document marked as exhibit 5 is the voter list of 1989, and which is available at page 58 of the TCR, and the document marked as exhibit 6 is a copy of Jamabandi, which is available at page 59 and page 60 of the TCR. However, the exhibit 6 and exhibit 5 and exhibit 6 have not been signed by the learned tribunal, though referred to in the examination in chief. Therefore, the court is of the considered opinion that the learned tribunal had failed to appreciate the evidence available on record, which is found to have vitiated the impugn opinion dated 24/9/2018, under challenge in this writ petition. This was on consideration of the exhibited documents makes the decision-making process of the learned tribunal as perverse. Next, accordingly, the court has no hesitation to set aside the opinion dated so-and-so, page 64, page by so-and-so, by so-and-so. Next, however, the proceedings of FT 141 of 2016 is remanded back to the said learned tribunal for fresh appreciation of the evidence on record and for passing a fresh opinion in accordance with law. Next paragraph. The petitioner, who is duly represented by his learned counsel, is directed to appear before the learned tribunal within the outer time limit of 28/9/2026. And we're producing a certified copy of the order, await for further this to be passed by the said learned tribunal. Next para. The petitioner, namely so and so, is also directed to directed that on the date of appearance, he will take a bail of such amount as the learned tribunal may so fix, and the learned tribunal shall accept the bail on the condition that it would remain valid for a period of 30 days beyond the period of beyond the date on which the special opinion is passed. This has allowed to the extent as indicated above the order of remand. Next slide. The registry shall send back, return back the tribunal's record with conditions. Next slide, the learned standing question for the border and method. Committed to send a download copy of the Home and Political within bracket B department for the record. This matter is demanded, along with a copy of the order to be made a part of record by the said learned tribunal. There is another error in our petition. Because we dictated that order and my sister was following it. We found out there is another mistake. You who is Hormuz Ali?
Hormuz Ali is the neighbor man. Hormuz Ali, neighbor. DW4. He is right now in 90 years of old.
Hormuz Ali, no, that's some mistake.
So what are the discussion on that?
Please read this again. That page 10 order, please read it again. That last part, three were examined and sent back.
জন সাক্ষীৰ শপতনামাৰ ওপৰত প্ৰস্তুত কৰাৰ অন্তত যাবলৈ দিয়া হয়।
Next one, yes.
দেখা যায় এজন সাক্ষীৰ শপতনামাৰ ওপৰত প্ৰস্তুত কৰা হোৱা নাই। এজন সাক্ষীৰ শপতনামাৰ ওপৰত প্ৰস্তুত কৰা হোৱা নাই। ধাৰ্য 4 দুইজন সাক্ষীৰ প্ৰস্তুতৰ বাবে।
2 number সাক্ষী।
1, 3 and 4 was examined.
1, 3 and 4 was examined.
The projected brother of the prosecutor. Although there is no given.
What is his name? PW2?
Safar Ali.
Hmm?
Safar Ali.
Safar Ali.
But he was concerned as OPWC. Where is he? 48.
Safar Ali, did he come for cross-examination? No, he came on, look at page 55. Sorry, 56. This is Safar Ali, recorded on 14/5.
Yes, 14.5. 14.5.
Who was the PW2?
Notice. Only his number. Muhammad Hussain Ali. He was examined on 30th August 2018.
Number 3, Safar Ali.
So that means there will be 5 witnesses.
Proceeding himself, his projected brother, Gambura and neighbor.
Okay, so 2 will defer. Just let me separate it, but I think from where we have referred to the witnesses examined, and we have referred to the order dated 14/5/2018, where you have referred that at the on 14/5/2018, OPW1, OPW3 and OPW4 were cross-examined and their examination in chief as well as cross-examination was recorded and discharged. So far as OPW2 is concerned, apart from his evidence on affidavit on record, he was examined and cross-examined on 30/5/2018 and discharged. We have discussed about their exhibits, huh? Will be adequate. Okay. We had read this, we had read it as exhibit PW1, 2, 3 were examined on 14/5 and PW4 was examined on 35. So that deposition which is available is recorded on 35. So we were thinking that is again an error of the tribunal. But that's not an error. Okay. You have to appear on the date fixed. Property 1/9. Yes, sorry. We appear on 28.
9/2026.
We appear on 28/9. Huh? Yes, right there. Please make clear that if the petitioner events happen on the date of within fails to appear within the time allowed, it would be open to the learned tribunal to treat the petitioner as absent on call and proceed to hear the matter in accordance with and proceed to decide the matter in accordance with law. But almost all the orders of this particular tribunal is being demanded back. So on similar grounds. Yes. Of not considering the evidence. Yes, sir. Last week.
Item 11.
May it please, my lords, I am appearing on behalf of Mr. A. Rahman, my lord. My lord, Mr. A. Rahman is indisposed today. He is sick, my lord. So I humbly pray that the matter may kindly be accommodated for a week, my lord.
We'll adjourn the matter, but in this case, the interim order was not to detain you or deport from the country, but the bail indemnity was not given. You're not asked to take bail.
Yes,
So
my
we are imposing a condition of taking bail. We are giving you 4 weeks time,
lord.
since you may not be in contact immediately, so we are giving you time to take bail and then report to the court. Both sides are represented. Pursuant to order passed earlier, the records of the travel is received, which requires examination. Accordingly, court is inclined to issue rule returnable forthwith without requiring any steps to be taken. Next paragraph. As this court, by order dated 19/12/2018, had directed that the petitioner shall not be detained or deported from the territory of India. So the court deems it appropriate that the petitioner be directed to take bail. Accordingly, court is inclined to direct the petitioner to appear before the Superintendent of Police within bracket border, bracket closed, Ruby, and take bail of rupees 5,000 to the satisfaction of the said authority. Condition will be there. I will say no, that condition will be there. Next. Taking note of the fact that. No, you just said that. No, you said that. Here made by unconstitutional petition is provided that the petitioner shall take bail within a period of 30 days from the date of the order. Wherein which the order of bail shall stand lapsed by a course of time. Next part. This is the matter for hearing in the week commencing. Give it after vacation, November.
Objection.
We will be 5 minutes late in assembling again.
Item 7.
This will have to be remanded to the tribunal because of the fact that in the proceeding, the KPP is not there. Government advocate is not there.
Yes.
So who did the cross-examination? Obviously, the tribunal. So it exceeded its mandate. Could have asked questions under 164, 165. Cross-examination cannot be permitted.
Malad, if I may submit, Malad, if Malad the cross part is expunged also, then also prosecution side Malad has the petitioner proceeding has failed to establish herself to link herself with the further. Malad, and this is this, so if I may permit to expunge the cross part, Malad, then only on the basis of the proceeding is placed by the proceeding, Malad. If it can be established, cannot be established, Malad, my clear is Malad, it may not be interpreted. Because had the Malad, the petitioner could establish, though his might not be evidences. Because what I have seen, there is nothing in the cross now.
You see, there's no difficulty to accept your prayer, but the problem is that we are exercising statutory jurisdiction.
Yes,
It's not an appeal, so that therefore this proceeding is not an extension of the proceeding.
yes.
Therefore, who will do the expunge? Who will expunge the evidence on record? It will either be the same court, because the appellate court does not have power to expunge the evidence. Under order 21 to 23A, matter can be sent back for a particular purpose. Under 23, the remand order can be made. But even the appellate court would not have power to expunge the evidence on record.
That is another aspect.
Evidence can be expunged only when there's the witness is not there for cross-examination. Then we say that the evidence which is on record is expunged, but that is not also done by the appellate court. It is also normally done by a trial. Therefore, we have no other option but to send it back. It would depend on the tribunal. They have the wisdom, they will expunge it and then proceed to hear the matter.
Secondly, my lord, even though, my lord, whether any materials are there.
There are no materials, absolutely.
No, my lord,
What we are showing that the documents are produced by the Gauhati.
my lord, my submission is whether the cross has prejudiced the petitioner somehow. My lord. Because the cross part has not prejudiced the petitioner, even though it is done by the my lord, tribunal. If we accept it as a my lord, part of the 165 my lord, evidence, 165 statement, whether it will prejudice the cross part which has been taken, it will prejudice the petitioner's case, petitioner somehow. That part may be examined. If it does not prejudice the petitioner, my lord, my submission will be, my lord, that may be ignored. This, because it is not explicitly, my lord, if yes, I admit, my lord, there is no explicit order or recording that it is taken under 165. I have seen the record. I admit, my lord, there is no explicit order or recording that it was taken under 165. But if it does not prejudice anyway to the petitioner, my lord, my submission. That means, my lord, if cross part does not lead the petitioner to be, my lord, declared to be foreigner. Only on the basis of their evidence, if it is, the finding can be seen that the finding was taken only on their evidence, my lord, then I think no prejudice will cause to the petition.
For example, let us forget about this case.
Yes.
We take a disciplinary proceeding. In a disciplinary proceeding, when the proceeding has commenced, there was impropriety in the presentation. For example, let us say that the evidence was led by the management witness. No witnesses were examined to prove the documents. And the recommendation was made to terminate him. Can we say that the High Court, when you are examining the disciplinary proceeding, that since no prejudice has been caused, we omit to look at the evidence and we proceed on the basis of material? Because you see, the inherent wrong was committed when the tribunal made a cross-examination.
Yes, that I admit, my lord. My lord,
Can we shut our eyes saying that since there is no prejudice, we omit that and then we proceed?
what my submission, my lord, under certiorari jurisdiction, your lordship may see whether any immaterials, my lord, whether any, my lord, evidences which were not supported or which were not placed before the tribunal were considered for coming into the conclusion by the tribunal or not. My lord, my submission is whether this part of the cross part, where those were taken consideration for coming into the conclusion that he is a foreigner. If that part is ignored only on the basis of their evidence, acquisition record, my lord. Can it be, if the finding is wrong, then yes, definitely your lordship may interfere. But if the tribunal has not taken consideration of those, my lord, cross part, for coming into the conclusion that the petitioner is a foreigner, then, my lord, I think, my lord, if that part is not considered, that may not be interpreted. That is what certiorari has says, my lord. If the tribunal has considered an material which were not placed before the tribunal, or if the tribunal has considered a wrong, my lord, materials, if this has been, if this is treated as wrong materials which were placed before the tribunal by way of cross-examination, whether the tribunal, while coming into the conclusion, my lord, has taken those part or not. If that is not taken, I think no prejudicial clause. If it is only on the basis of their evidence,
Well, I have some answers.
yes, my lord, even to solve.
My lord, and-
If your lordship may see the 113 of the, my lord, the Muslim Mandal. Just I'm reading 113 of the Muslim Mandal, my lord. 2013 1038091. Because here it is, my lord, relying on the apex court. The court says there is no jurisdictional error here. There must be an error apparent on the face of the record, as the High Court acts merely as supervisory capacity and not as the appellate authority. An error apparent on the face of the record means an error which strikes, that is not the issue here, my lord. Such error should not be required. This is not, such error may include so and so. Then, my lord, it may also include the application of wrong legal test. That is not the issue here, my lord. Facts found, taking, my lord, this part, my lord. Facts found, taking irrelevant consideration into account of failing of take relevant consideration into account and wrongful admission or exclusion of evidence, as well as arriving at a conclusion without any supporting evidence. My lord, my submission is, my lord, if the tribunal has not admitted this, my lord, the cross part, It is not a wrong, it will be not a wrong premise.
No, that is there in the finding, it is there. Please come to that opinion. It is at page, come to page 68 directly.
Page 68, madam.
68, subparagraph 3. The land documents, those submitted by the evidence, OPW 3 stated that there is no land in the name of the father. Thus, there is total variance in the statement made in the written statement and cross examination. That was definitely taken into account.
No, that is there, madam. OPW, what my submission is, statement of the OPW 3, that can be considered. But whether during my consideration, the cross part, what is recorded in the cross, that was considered or not. If it was not considered,
When it is considered, how will we look at 3?
consider.
Page 68, subparagraph 3.
That's why the land documents although submitted.
No, here is in 67, last person, in his cross-examination, OPW 2 has stated that his house is 1 kilometer away from the house.
That is not a contradiction.
That is not on that.
But 3 is there.
See, your
There
lordship,
is total variance in the statement made in the written statement, evidence and cross examination.
yes. Evidence if found there is total variances follows. These things matter. This is evidence matter, evidence and WS. What my submission is
Read
cross.
also, you read that.
In the proceedings, so and so, the case
No,
against
number 3, come to 3. You don't
the
have.
land document. The land documents. What matter? The land documents although submitted, but in the evidence of OPW 3, it is in the evidence of OPW 3, as stated that there is no land in the name of father, not in cross.
Continue reading. Don't read
Thus,
one part and then.
There is total variance in the statement made in WS evidence and in cross exam.
So in the cross examination is there. Please come to that OPW 3. The cross examination is at page 64.
Basic.
Fourth line. My father has no landed property in his name.
No problem.
64.
Yes, yes. My father is no longer. Yes. That part is there, ma'am.
And Mr. Payang, our difficulty of both of us here in the bench is that we are trained to look at the evidence as a whole. We can't pick and choose one part and
Yes,
then
yes.
say that this part is omitted, this part is doesn't prejudice, this part
Yes.
is justified. We read the evidence as a whole.
Yes, that is
That is,
true, ma'am.
the Supreme Court also says this, not to pick up part and throw out another part.
So that we all still have to go for training.
Upgrade it. How many letters can you write? How many letters can you indicate? In between our IT and president. My lord, I have one. In between, how many matters? My lord, only one sentence, my lord. When the tribunal has taken some active part by way of cross-examination to the witnesses, so a big question mark arises regarding the acceptability of the judgment. So that is a very important question because court should be neutral till the judgment is delivered. So when he has actively participated in the prosecution, rightly or wrongly, whole judgment becomes questionable. In that view, my lord, my humble prayer is that what lordship has taken the view that should be as I understood. So, my lord, it may kindly be remanded and give me a kindly given. So, lordship has already understood how much foolish I am. How much foolish I am. Even I cannot say the name of my brothers. Even then, my lord, I leave it to lordship's wisdom because this honorable High Court has ample power. And one prayer, my lord. My lord, I have a matter at court number 19. May I go, my lord? My junior would be here. Obliged. Highly obliged.
If your lordship is supposed to remand, my lord, my prayer will be, my lord, they may be only allowed to cross-examine the, my lord, that part of, only from that is cross-examination of these three witnesses, whatever is there.
No IPP, no GP appointed.
Yes, ma'am.
Then the cross will be expunged. It will
Yes.
be only the evidence on record
Yes, ma'am.
on that basis. And if the tribunal wants it, can
No further, my lord, evidence.
no further evidence.
How less?
But Mr. M.U. Mahmood, learned counsel for the petitioner and so for the respondents. Next, by filing this writ petition under Article 226 of the Constitution of India, for the petitioner as a saying, the opinion dated page 65, 25/6/2018, passed by so and so in case number so and so, corresponding D case number so and so, by which the petitioner was declared to be a foreigner post 25 to 1971 stream. Next. pursuant to the directions issued by the Election Commission of India, comma, the electoral registration officer of 85 number Rupohi the LAC, comma, on a doubt directed an inquiry to be carried out by the local verification officer about the doubtful citizenship of the petitioner. So stop. Based on the LVO report, comma, the electoral registration officer submitted the reference to the jurisdictional superintendent of police and accordingly the superintendent of police within bracket border bracket close Nagaon, comma, being the competent authority, comma, had made a reference before the then chairman, comma, illegal migrants within bracket determination bracket close tribunal, Shankardev Nagar, comma, Hujai, comma, district Nagaon. So stop. In course of time, the illegal migrants within bracket determination by tribunals bracket close Act, 1983 was declared ultra vires by the Supreme Court of India in the case of Sarvanand Sonowal versus Union of India, comma, within bracket 2005 bracket close 5 SCC 665, and accordingly the reference was transferred by virtue of the said order of the Supreme Court of India to the jurisdictional tribunals to stop. The proceeding against the petitioner was transferred to the learned member, comma, foreigners tribunal, third, comma, Nagaon. Next one. In view of the order of demand, comma, which is proposed to be passed, comma, the pleadings and the evidence has not been referred to in this order. Next. It would suffice to mention that the petitioner had examined 3 witnesses, namely herself as OPW1, comma, Mohammed MD, Mohammed Jamir Ali, JAMIR Ali. Oh, sorry, mistake. Mohammed Fakrul Islam, FAKHRUL, Fakrul Islam, or the government Gaura of village Barpeta as OPW2, and Mohammed Jamir Ali, JAMIR, Jamir Ali, comma, the projected brother of the petitioner as DW3, OPW3, full stop. While the petitioner did not exhibit any documents, comma, the government Gaura within bracket OPW2 had exhibited five documents being the voters list of the certified copy of the voters list of 1965 within bracket exhibit 1, comma, certified copy of voters list of 1970 within bracket exhibit 2, comma, copy of, no, sorry, the Dated 15/3/1955. Then packet exhibit 3. The direct copy of Jamabundi within bracket exhibit 4. And government Bambura certificate within bracket exhibit 5. Certificate dated 19/7/2016 within bracket exhibit 5. Now the documents were exhibited by the OPW1, IE, the petitioner, or by the OPW3. Next one. What reveals the tribunal's records reveal that the presence of the government leader is not recorded on any dates, and even in the fuel opinion, the government leader for the state is shown to be none. How, the tribunal's records disclose that the OPW1 was cross-examined and discharged on 21/2/2018, the OPW2 was examined, cross-examined and discharged on 15/5/2000. OPW2 and OPW3 were examined, cross-examined and discharged on 15/5/2018. Next one. Yep, the order sheet do not show as to who was the person who had cross-examined the proceeding, the petitioner and 2 other witnesses. The inevitable presumption is that the learned tribunal, instead of asking questions in exercise of power under section 165 of the Evidence Act, had proceeded to cross-examine the 3 OPWs. Next one. The learned candidate for the border and FP matters has vehemently opposed any adverse influence to be drawn on the cross-examination of the 3 witnesses examined by the petitioner. It is submitted that as the reference was made long back in the year 1998, this court may, if it deems appropriate, expunge the cross-examination of the 3 OPWs. It is also suggested that it is also submitted that as the nature of cross-examination is not found to prejudice the petitioner, the court may proceed to determine the issues raised in this petition. By referring to paragraph 113 of the case of State of Assam versus Muslim Mandal, within bracket, within bracket 2013, bracket close 3 GLR 402, equivalent to 2013 within bracket 1, bracket close GLT 809, it has been submitted that in exercising power and jurisdiction under statutory jurisdiction of the High Court under Article 226 of the Constitution of India, this court not being the court of appeal or revision is only required to examine if the impugned opinion is initiated by any jurisdictional error, or that there was a failure of justice, or that the learned tribunal, while deciding the issue, has taken into consideration extraneous materials for its decision, or that if wrong legal tests are applied under the facts of the case, or taken into consideration irrelevant considerations. So it is submitted that examination by the tribunal, merely because it is mentioned as cross-examination, ought to be treated as one as questions put by the learned tribunal under section 165 of the Evidence Act. Accordingly, it is submitted that there was no jurisdiction error, save and except wrong noting of the questions put by the tribunal as cross-examination. Next paragraph. It is also submitted that even if the evidence of the petitioner and other two witnesses are taken in its face value, no case is made out by the petitioner for interference, because the petitioner had not exhibited any document, and that the documents which were exhibited by the government Gauhati within bracket OPW2 cannot be said to be produced from a lawful custody, as the Gauhati has no duty to keep certified copy of the voters list or the original sale deed within bracket exhibit. Three. It does not belong to him. Next one. Consider the submissions made at the bar as well as produce the records. Next one. In the considered opinion of the court, tribunal, in the absence of the government advocate, would not have jurisdiction to cross-examine the witnesses produced by the petitioner. Therefore, a mere mention in the corresponding order dated 14/5/2018 not 14/5, it is 21/2/2018 and 15/5/2018 that the witnesses were examined, cross-examined and discharged. Is sufficient to presume, in the absence of the government, presence of the government presence recorded in the order sheet, that instead of asking questions to the petitioner in exercise of power under section 165 of the Evidence Act, the tribunal had proceeded to cross-examine the three witnesses present. Act of the learned tribunal to cross-examine a witness, take the learned tribunal as the prosecutor and the judge. Set action of the learned tribunal to cross-examine the witnesses, counter initiated the proceedings, and accordingly, the court is inclined to set aside the impugned opinion dated so and so, passed by so and so. However, the proceedings of the said FT case number so and so is remanded back to the learned member, foreigners tribunal, third, Nagaon, to take up the proceedings from the stage of cross-examination of the witnesses. It is further provided that in the event the government pleader is not present, it would be open to the said learned tribunal to put questions under section 165 of the Evidence Act, corresponding to section 169, 168, the Bharatiya Sankhya Adhiniyam from 2023. If so desired, or it will proceed to consider the submissions made by the appearing parties and decide the reference afresh as far as practicable within the time prescribed under paragraph 3 within bracket 14. of the foreigners within bracket tribunals, bracket close order, corresponding to paragraph 17 within bracket 14 of the Immigration and Foreigners Order from 2025. Next one. Result, as a result of the discussions above, the writ petition stands allowed to the extent as indicated above. An order of remand of the matter back for first decision by the said learned tribunal. Next paragraph, the petitioner is duly represented by her learned petitioner, namely so and so, who is duly represented by her learned counsel, was directed to appear before the said learned tribunal within the outer time limit of 29/9/2026, and by producing a certified copy of the order, wait for further directions to pass the said learned tribunal. Next paragraph. On appearance of the petitioner, the petitioner shall take bail of rupees 5,000 to the satisfaction of the said learned tribunal. So it is provided that the said bail shall remain valid for a period of 30 days from the date of passing of the fresh opinion by the said learned tribunal. Next, the registry shall return back the tribunal's records expeditiously, along with a copy of the order, to be made a part of record by the said learned tribunal. No orders to possible. Next, the learned and question for the border and FT matters. It's permitted to send a download copy of this order to the Home and Political within bracket B department in the audit for their record. Your appearance should be within 29th of September.
Okay.
Before that date. So on that date, if you don't appear, you'll be just in the event the petitioner does not appear within the time allowed. Will be open to the learned tribunal to treat the petitioner as absent on law and proceed to decide the matter of which in accordance with you. Okay.
Item 12.
May I please, Lord?
Here, research in Sharma, please examine this, at least in my reading, because obviously I'm not thoroughly reading it. I find that the testimony of witnesses other than DW3 is not discussed. Just see that. You have a copy of the information, give it to you. Except for that,
Lordship is not audible. Lordship is not audible. Lordship is not audible.
oh, is it? You are getting the voice now? No.
Sound.
Okay, wait, I'll use this. In fact, we find that just make it so. We find that except for discussion on DW3, other witnesses were not discussed. That is the apparent flaw we noticed. Apart from that, the petitioner has no case. The Qazi was not examined, so Exhibit 7 goes. The voters list of 66, 70, 85 were discussed, which will not be able to link the petitioner with that voters list. There's a linked document by the chairman, but it has state emblem. So except for that flaw,
Herein, Your Lordship, 3 persons were examined, but in the impugn opinion, Your Lordship, only discussion was made regarding the DW1. Rest of the
you
two,
were not following us.
yes. That point Your Lordship is discussing.
I have to go back. Heard. Mr. A.M. Khan, then transfer the also it's also for the respondents. Next para. By filing the petition under Article 226 of the Constitution of India, the petitioner, namely so and so, has sealed the impugned opinion dated 6/10/2018, page 22, passed by so and so. In case number F, in FT case number so and so, police reference case number so and so, by which the petitioner was declared to be a foreigner post 25 to 1971 stream. Next paragraph. In view of the order of demand, which is proposed to be passed, the court does not find any reason to burden this order with discussion on the pleadings and evidence on record. It would suffice to mention that as per the tribunal's records, as per the tribunal's records, the petitioner had examined herself as DW1 one Molobi MOU LABI Abdus Samad ABDUS SAMAD was examined as DW2 who projected himself to be the uncle of the petitioner, and one Sahinur SAHINWR Begum, chairman, VCDC, Kaljhar KALJHAR under Kokrajhar district as DW3. Full stop. In the decision and reasons, the learned tribunal is found to have discussed the evidence of DW3, but the said learned tribunal had not made any reference to the evidence of DW1 or DW3. Next paragraph. Although the learned standing counsel for the border and FT matters has made its submissions to defend the impugn opinion, but in the considered opinion of the court, the lack of discussion on the evidence of DW1 and DW2 is found to have vitiated the said impugn opinion dated 6/10/2018. Next, as the foreigners travels are dealing with the issue of citizenship, it is expected that whatever evidence is led by the parties would be discussed by the said learned tribunal while rendering its opinion. Next paragraph. Accordingly, on the opinion being found to be vitiated in the absence of discussions on the evidence of DW1 and DW2, the impugn opinion dated 6/10/2018, as by page 22, is hereby set aside. Resultantly, consequently, the proceedings of FT case number 248/F/15 is remanded back to the said learned tribunal for a fresh decision after considering the evidence of DW1 and DW2. Also, next paragraph. The petitioner, namely so-and-so, who is duly represented by a learned counsel, directed to appear before the said learned tribunal within the outer time limit of 29/9/2026, and by producing a certified copy of the order, wait for further orders to be passed by the said learned tribunal. Next paragraph. On appearance of the petitioner, she would take bail of rupees 5,000 to the satisfaction of the said learned tribunal. The said bail would be on a condition to be valid for a period of 30 days from the date of the fresh opinion to be passed by the said learned tribunal. Next, the registry shall expeditiously return back the tribunal's records along with a copy of the order to be made a part of record by the said learned tribunal. Before that, you say that in the event the petitioner does not appear within the time at all, it will be open to the learned tribunal to treat the petitioner as absent on call and proceed to decide the matter in accordance with law. Then this tribunal record will be sent back. Next, the lead petitioner stands allowed to the extent as indicated above with an order of remand. There shall be no orders to cost.
Item 13.
I think in terms of the order dated 20th September 2024, petitioner has submitted his written submission, is marked as flag X, and thereafter, in terms of order dated 22nd of May 2026, argument is complete, matter is reserved for order, Impugned opinion passed by the learned tribunal below is annexure R page 71,
Just a moment. Who is DW3?
One Ibrahim Ali, madam.
Who is he?
He is my neighbor, madam. His evidence is at page 52, madam.
Then you have no case at all.
But madam, that very tribunal declared my elder sister as not foreigner. And that's not S. And in my pleading, my lord, in written statement, I have categorically stated about my that elder sister. She also herself stated in her pleading that I am her brother. That's why, my lord, both the tribunals recorded before your lordship.
You see, in your case, you exhibited only 6 documents. 7 documents.
My lord.
Out of the 7 documents, none of the document is the opinion of the other case. You did not tender any evidence. The evidence was tendered by DW3, who is your neighbor. Neighbor has no business to keep your voters list and exhibit it.
My lord.
Then the reference to your decision of your other family member, your sister,
My lord.
is not here.
Annexer F, my lord. Page 78.
And this sister did not come forward to give evidence.
But my lord, in that reference as well as in my reference, my lord, both in the both two references, my lord, my mother came. And my mother stated that she is my daughter, and in this reference also said that he is my son.
But she did not exhibit any document. You did not exhibit any document. Your neighbor comes and exhibits document. He is not the custodian of your document. In which manner this that record has been brought to the notice of the tribunal? That has never been done. Your opinion is at page 71. Where is that earlier opinion of your sister? Which page is that?
78, my lord. Annexer F.
78.
Page. Opinion is of 24/7/2018. My opinion is of 6/9/2018. From the same tribunal, madam.
Right. Clear opinion was not brought on record, but the documents are same and the names are matching, except for some spelling error here and there. We will show you a comparative reading. Please come to page 73. And please juxtapose it to page 81. We are reading these two pages together, 73 and 81. In 73 in the middle, you will find that the name is Sukijan is my mother, Lalmud alias so-and-so are the grandparents. There are 4 brothers and sisters, namely he himself. Here the name of the proceedee is the petitioner, namely Usuf Ali, USAB. Correct. Now come to page 81. Opposite party of 4 brothers, 2 sisters. In the middle part, third half of the paragraph, and then the names are at page 80. Please come to that page 80, last 5 lines. Thereafter, opposite parties are 4 brothers and 2 sisters, namely Yusuf Ali, only P and F, Mughal Hussain. Here it is Maqbul Hussain, page 73, MOKBUL. Third name is Altaf, and fourth is Azibur Rahman. 2 sisters are opposite party at page 81. The person is Samira Nessa. Page 73, you will find Samira Nessa. And page 74 is the name Momiron Nessa. At page 80 also you will find that Momiron Nessa. And here also 6 documents, here also 7 documents. Basically same, it is matching. I have to send it back to give an opportunity to the petitioner to prove this. Page 78 we missed out. Because if the siblings are declared to be an Indian, then he has a right to but it is so sad that you see from page 71, advocate is same, Abdul Latif Ahmed. And in the second case, also Abdul Latif Ahmed. So same advocate appearing for two different persons and these are not being
Yes, yes.
shown. Time has come to use whether we should use the word learned advocate at times. Same advocate, brother and sister, in one case he is not exhibiting the other opinion. First opinion was passed on,
24,
the first opinion 24/7/18, second opinion is 6/9/18. And his right mother has come in both the cases.
in WS note 3.
Page 58 is the evidence where this is disclosed. Now, if you come to this written statement, it starts from page 35, and you will find the names given at paragraph 14, page 37. You have seen that?
Yes.
Names are disclosed.
Paragraph 14, page 37.
All are matching it.
It's there. Heard. Mr. U. Das, learned counsel for the petitioner, and so for the respondents. Next, by filing this writ petition under Article 226 of the Constitution of India, the petitioner, namely so has at page 71 has assailed the opinion dated 6/9/2018, passed by the learned member of Foreigners Tribunal number 5th, Gauhati, in so ERO reference number so by which the petitioner was declared to be a foreigner post 25 1971 stream. Next paragraph. In view of the order of demand, which the court proposes to pass, the pleadings and the evidence has not been referred to. Next paragraph. It would suffice to mention that the electoral registration officer, expressing doubt about the nationality of the petitioner, had the matter investigated through a local verification officer, and thereafter made a reference before the Superintendent of Police within bracket border, Superintendent of Police, Gwalpara, who is the authority competent to make reference. So accordingly, a reference was made, doubting the nationality of the petitioner. To stop. The petitioner appeared before the learned tribunal and filed his written statement, wherein he has disclosed about his grandparents, parents, and the siblings. To stop. The petitioner had examined. How many witnesses were there?
Petitioner himself is one, petitioner's mother, and his neighbor. Three people.
Okay. And examined three witnesses. Four witnesses. Being himself as DW1 Congress Sukjan Rohan Sukjan Nessa SUKJAN Nessa NESSA alias Sukiron SUKIRAN as DW2 Ibrahim Ali as DW3 and Jainal Abedin JOYNAL ABEDIN as DW4. First off, the DW3 had exhibited 7 documents, being voter list of 1966 within bracket Exhibit A, voter list of 1970 within bracket Exhibit B, voter list of 1971 within bracket Exhibit C, voter list of 1985 within bracket Exhibit D, voter list of 1989 within bracket Exhibit E, voters list of 1994 within bracket Exhibit F, and voters list of 1997 within bracket Exhibit G. Full stop. Full stop. The learned tribunal, on examining the voters lists, discarded the evidence of the petitioner on the ground that none of the exhibited documents disclose his presence as a voter. And accordingly, in the absence of any documentary proof, the verbal evidence projecting that he is the son of Shona SHONA, Shona Ullah, was disbelieved, and he was declared to be a foreigner of post 25 to 1971 stream. Next paragraph. The learned counsel for the petitioner has referred to Annexure S of this writ petition, which is the opinion dated 24/7/2018, passed by the same tribunal, IE, Foreigners Tribunal number 5th, Gwalpara, page 78, passed by so-and-so in case number so-and-so, ERO reference number so-and-so, by which the proceedee therein, namely, Samiran, SAMIRAN, Samiran Nessa, was declared to be a foreigner of post, not a foreigner, but an Indian. The next paragraph, the learned counsel for the petitioner has been able to demonstrate from the contents of the paragraph 4 of the opinion dated 24/7/2018 and paragraph 4 of the opinion dated 6/9/2018, that the names disclosed by the in both the cases regarding the grandparents, or parents, and the 4 brothers and 2 sisters to be almost similar, save and except some spelling variants in the names. Full stop. The learned counsel for the petitioner has also been able to demonstrate that the 7 documents which were exhibited in the present case were the same set of documents which were exhibited in connection with FT case number P78, FT case number so and so. Next paragraph. The learned standing counsel for the border and FT matters has vehemently objected to the court taking cognizance of the opinion dated 24/7/2018, passed in the case of Samiran Nessa, SAMIRN, on the ground that though the said opinion was passed on 24/7/2018, the said opinion was not exhibited in the present proceedings. Next paragraph. Be that as it may, as the court finds that the nature of pleadings and evidence is, in both the cases, are quite similar, save and except the variance in the name of variance in the spelling of names, the court is of the considered opinion that as the petitioner now projects that one of the siblings, being his sister, namely Samiran Nessa, SAMIRN, Nessa, has been declared to be an Indian and not a foreigner, on that ground alone, the present writ petition would be maintainable. What is that Supreme Court decision? It says that once a sibling has been declared, the
Abdul Quddus,
Abdul
para
Quddus.
28.
Writ petition would be maintainable. In this context, the court
2019,
is inclined to be guided by the decision of the Supreme Court of India in the case of Abdul Quddus versus Union of India and others, what is the decision dated? Citation is
Citation 2019, 6 SCC 604.
604. Next paragraph. Accordingly, the court is of the opinion that the petitioner be given one opportunity to prove the to reduce to bring on record in an appropriate manner the opinion dated 24/7/2018 and to bring on record and to given record the opinion dated so and so and to do the needful as the petitioner will be so advised. Next paragraph. To facilitate the opinion dated 24/7/2018 passed by the said learned tribunal in case number page 78, the court is inclined to set aside the opinion dated 6/9/2018, page 71. Full stop. Consequently, the matter is remanded back to the said learned tribunal to afford one opportunity to the petitioner to bring on record the opinion dated 24/7/2018, referred above, in manner as the petitioner will be so advised. Next paragraph. The petitioner, namely so and so, who is duly represented by his learned counsel, is directed to appear before the said learned tribunal on or before the outer time limit of 29/9/2026, and by producing a certified copy of the order, await for further orders to be passed by the said learned tribunal. And on the same date, the petitioner shall take appropriate steps as he may be so advised. Next para. Thereafter, the learned tribunal shall pass a fresh opinion in accordance with law, as far as practicable within the time limit prescribed under paragraph 17, within bracket 14 of the Immigration and Foreigners Order, 2025. Next, it is made clear that if the petitioner remains absent on the it does not appear within the time allowed, it will be open to the said learned tribunal to treat the petitioner as absent on call and pass a fresh opinion in accordance with law. Next, the registry shall return back the records of the tribunal dispute. The records of both the proceedings expeditiously, along with a copy of this order, to be made a part of the record by the said learned tribunal. Next, the expedition stands allowed to be extended as indicated above with an order of remand. Next, the parties are left to bear their own cost.
There is no link at all also. On the statement and pleadings are matching document, but there is not a single document by which he can connect his projected father whose name is.
There is a reason for that. That's why the first paragraph in the order we said that his reference was made by the ERO. So therefore, first day his name came into the voters list. He was doubted as a citizen, and therefore his name is not there. But on the same set of documents, sister has been declared to be a Indian. It depends on them. Yes, Mr. Das. Every time you are here, we can't complete the board.
I think we'll have to buy time. Time will come, we can buy time from the court.
That is a good suggestion.
Notice has to go, the violation of content of the order for the reporting. Case 53.
But I was under a different impression. We both were under a different impression that by getting time here, you gain more.
No, we don't get. That's a wrong concept.
I don't know.
I know about what is going on. It's a wrong.
Because when I was there, I used to show that feeling of.
It is applicable some in some course, up to some person, not to all. Yes.
Just a moment. Any other matter where interim orders are to be extended? No. There was a request to upgrade one matter. Your matter, which is that one? Item? 39. Just keep that record. Your item is item number, Mr. Das? 18. 16.
It's a violation of the court's order that is always there. They do not follow court direction under the.
This is that APC matter.
Follow that compensation your lordship has done. Person who was.
Oh, acha.
My lord, only thing is that I would say, my lord, let the notice go to respondent number 1 and 2. Others are not relevant, and your lordship may direct the government to government advocate to accept the notice, because your lordship can do that under the High Court rules. Either send notice or otherwise. Because page 53 is the. No, it is 16. Let it go to respondent number 1 and 2 for the time being, my lord. So the others are, may not be relevant. And these ballot, they are always represented by government. Just a moment. I think we committed a mistake in this order. We did not give a time limit within which the payment is to be made. When your lordship passes the judgment, Madam, providing for thing, Madam, then it is always 1 month. Okay, I have read a Supreme Court judgment on it. Earliest it also means 1 month. But this is a mistake on our part. It normally shouldn't have happened. Time limit is not there, but that doesn't mean Madam from the award. Otherwise, we have it in mind, Madam, time limit and also interest review. It's error on our part. Okay, I heard Mr. B. Das, Senior Counsel, assisted by Mr. HR Das, Senior Counsel for the petitioner. Next, Madam. Alleging willful default and non-compliance of the judgment and order dated 3/6/2026, passed by this court in WBC 392 of 2024. The present contempt petition has been filed under section 11 and 12 of the Contempt of Courts Act, there with Article 215 of the Constitution of India. Next paragraph. The learned counsel for the learned senior counsel for the petitioner has submitted that pursuant to the said order dated 3/6/2026, the respondents were put to notice of the said order by demanding payment of compensation by letter dated 5/6/2026, which was sent by registered post, speed post with AB, and the postal track report is also annexed to this application, indicating that the notices were the notice
dated 5/6/2026, but duly delivered. Next paragraph. At this stage, the court is inclined to issue notice on respondent numbers 1 and 2. Or requires them to show cause as to why the order of the court has not been complied with. Just stop. As the next part, he said respondents would take notice that that their personal appearance has not been dispensed with, and therefore, unless their affidavit is filed within the time allowed, the court would have no option but to call for their personal appearance. Next paragraph. The respondents are put to notice that the pendency of this contempt petition shall not be a bar for compliance of the judgment and order dated 3/6/2026, passed in WBC 392 of 2024. Next paragraph. Petitioner shall take steps within 2 days. This will be notices made returnable on, give a date after 4 weeks, returnable on Wednesday, list on Wednesday.
I just wanted to point out that notice, I find that it is recorded also. The form of the notice is defective.
Yes, it goes in the same form. High Court notices go in the same form.
But here, why I'm saying defective, because in one case I find that the court directed to appear before the court, and it says or through the council. The notice, because
That's personal appearance. That's why we have made it clear.
Your lordship's order is all right, but while sending the notice, the form is defective. That's what I just wanted.
Oh, acha. Yes.
So even if your lordship says you appear or dispense with a personal appearance, this notice will go. So that was my point of view.
We have this page number.
Page 278. Second, you are hereby directed to attend this court on so.
No, I think we have a different book. That's how.
Not through council.
That's right. No, this is not one.
Take that another. Form of notice under Rule 6, please. May I hand over this?
So we have this.
That defect is here, Malak.
Just literally.
In person or through council, it goes automatically. Normally, in contempt matters, I find Malak court issues.
No, there is a note there. This appears to be a decision of the High Court taken specifically. Note 3, this alternative is to be mentioned only in cases of civil contempt.
No,
That means it's a conscious decision of this court to permit notice by.
or through council, that goes automatically, or through council.
Because of note, the note 3 is there. This is an alternative.
Is to be mentioned only in cases of civil contempt.
Civil contempt. So that means the High Court has taken a conscious decision. Why
Because
this?
unless your lordship dispense with, they have to appear. So your lordship will dispense with, that's not, but there has to be a conscious order of the court for dispensing with the personal appearance.
Yes, that's
Simply
true.
issuing notice, then you will have to appear.
Yes.
So normally it is not done. Obliging.
Experience
I'm
is a
just
good
pointing out.
experience is a good teacher. That's why I have started using that.
Because I find in the other day when the court's order directed for appearance, but the notice said you appeared through council.
Because The problem is that from about 6 o'clock in the morning, the day starts.
And
Yesterday it ended at 12 o'clock.
heavily burdened, that's what we understood.
Yesterday at 12 o'clock it ended. Today morning 6:30 I am awake with the files.
These
At times we become very mechanical.
are the matters we are required to discuss.
Yes, yes.
Can a court sustain so much of pressure? It is not possible.
We don't know what.
No, it's not possible. It's
No,
not
now we have
humanly-
learned something more.
It's not humanly possible.
No, there is another reason what I have discovered now. Why our appointment orders are called warrant. The day this warrant is served, the police picks us up, takes us to wherever they want us to be there. Then in the morning they come and bring us again here. So all that time, when you are,
Whole system is.
When you handle the system.
is to the society. So lordship is heavily burdened. We are also facing a lot of problems because nobody is trying to address the situation.
there are many reasons. Yeah.
Many reasons are there. I understand that, but and we, as a result, one of the litigants are suffering.
No, the problem here in this, at least in this bench, is different. Since you have raised that issue, you know, in the motion column, in this foreigners bench, I have in 2017 3 cases. 2018 I have 85 cases. 2019 I have 515 cases. We got that identified by the registry. 2020 I have 189 cases. 2021 I have 395 cases in motion. So more than 1,000 cases.
Yes.
And so therefore, some cases we have to dispose of at the motion stage and we can't go to the admission. And now we are taking up hearing at the motion stage, taking up hearing in the admission stage. The hearing cases do not even reach.
I was just told by one of our friends here, Manoj, while the proceedings was going on. So when somebody is declared foreigner, they are not arrested. They are not.
That we can't say. We can't stop doing our duty.
Practical things and the lordship knows.
Like in your case, if the compensation not paid, doesn't mean that we will stop passing orders of compensation.
Not that, but I'm saying that.
No, you are right. You are right. There's some flaw in the system. We can't.
And because your lordship cannot hear what we discussed here or in the room.
Yes, there's one matter we'll take it up tomorrow because we have to rise. My esteemed sister has a single bench. Your item was item number 39.
Contested matter, Your Lordship. On the other hand,
You're basically paying for bail.
yes, my lord, I have every document, sir, 1966, 70.
What is your age?
Land documents, Your Lordship. My age.
You can be in the with that age you can be in the
Lady, Your Lordship.
with that age you can be in the center for some time.
Yes, my
You are
lord.
delayed by 3 years.
Yes, middle of 2024, Your Lordship. True, Your Lordship. Might delay.
Okay, what is the best document you have?
My lord, I have documents 1966 voter list, Your Lordship. Can
No,
I
no,
come-
don't go by the voters list. Any other document except the voters list.
Oh, yes, my lord, land documents, Your Lordship.
Where is that?
Land
Which page?
documents, my name is there along with my grandparents, parents, Your Lordship.
Which
Kindly
page
come
is
to
that?
Number 90, Your Lordship. 90. 90 type of Your Lordship and
This doesn't help you. There's a simple reason. Come to page 92. This 92 order of the settlement
yes, my lord.
was passed in the year 19, that is, okay. You may get a benefit. 1972, okay. You may get a benefit, just a moment.
Let's look 100, Your Lordship, my
Just a moment. What is the name of your father?
Zafar Ali, Your Lordship.
Huh?
Zafar Ali. But in the voter list of 1960 and 70, it's come at Zamar Ali, Your Lordship.
Jafar Ali.
Yes, ma'am. Only because
Jafar Ali is in this page 92, which serial number?
Oh. Serial number, Your Lordship. Page number. Uh, 69, Your Lordship. 69.
69.
69 serial number, madam. Page number 96. Zafar Ali, late son of Kolimuddin. Kolimuddin is my grandfather. Thereafter, Ruksan
So
Ali.
this is an entry of recent origin, maybe 2018-19. So this doesn't lead you to a person whose presence is there in prior to 71.
71. No, my grandparents' name is there, Your Lordship, from the 1966, Your Lordship.
That is the voters list.
No, my Lord, 92, Your Lordship. 92. Page number 92. It does.
Shows the name. We are asking for you for that.
Oh, yes, my Lord. Tarifuddin is my grandparent.
Serial number
3.
Tarifuddin.
Yes, my Lord.
Now shows your voters list of 66.
This is voter list, Your Lordship, and come on page number 84.
84.
Yes, my Lord.
That number 3 Tarifuddin is not here.
Tarifuddin is not here. This is my father, Your Lord. Zafar Ali.
No, but how do you see? We want you to connect yourself to a person who is there in 71. That is not there.
Tarifuddin is my great grandfather, and Kolimuddin is my.
It shows the connect. You are graduating from grandfather to great grandfather. So there must be some connect somewhere.
90 is the length of it, is the serially connected, Your Lordship. First time
Please show us. We are asking you to show us the best document.
Then, yes, serial number 3, Tarifuddin is my great grandfather.
We understand, but how do you show that from documents?
Serial number 66, Kolimuddin, son of Tarifuddin, is my grandfather. Thereafter, my Lord, 69, Zafar Ali, son of Kolimuddin, is my father. Thereafter, 76, Rohiton Nessa, daughter of
66.
Zafar Ali.
66.
66, only.
Which serial number you showed us? 67. Kalimuddin.
Yes, 67. The election in India, voter ID has been issued.
No, this doesn't help you.
Rohiton Nessa, daughter of Zafar Ali.
This
My
does not help
name
you.
is not.
This does not help you.
And this land documents has been proved by the Lakman Road as exhibit G. J.
Which page is the opinion?
Opinion mirror kindly come on second.
Okay, page 44.
44.
We have a difficulty in accepting it. Your reference is IMDT reference. Perhaps questioning your entry in the voters list by an ERO reference.
Yes, my lord.
So therefore, in 98, the case was filed before the IMDT.
Yeah.
And you say that the person now at serial number 3 is your grandfather, great grandfather.
My lord.
We don't have the date of death of your great grandfather. And this mutation order has come in 2019. First from the name of your grandfather to your father, and then from your father to you. All simultaneous.
No, my lord, the order is there, your lordship.
2019 order of mutation from your great grandfather to your father. It takes effect simultaneously.
Oh, from my great grandfather to my father, my lord, from the 2019 years.
Yes, that's what you are saying.
Yes, sir.
By the time you are showing us, we have read this. 2019, it takes place then from 2019, from your great grandfather to your father, and from your father to you.
From my father to me, your lordship, that is also 2019.
We have seen that.
Different place, lordship. Our area, your lordship, names are not matching, villages are not matching, lordship. And
There's a mismatch in names also.
yes, yes, sir.
No, for the time being, we'll consider this and then we'll take up on merit, we'll take it up.
My lord, anyway, total is, your lordship, 88.
No, see that today we don't have time. My esteemed sister has a single bench, we don't have.
Yes,
We thought that if you could show us one document which could satisfy us, we would have given you bail, since you are a lady, but
in the total list of 1989, my name is there along with my father, your lordship. But I could not produce before this side.
you are a D voter, you will not get a certified copy.
My lord, it's a voter list of 1989, at the residence of my father, your lordship. My name is there along with my father.
But it would be a D voter.
At that time, yes, my lord, at that time I was a D voter from the resident of my husband.
There are certain things we can presume.
It is earlier.
We have been dealing with this for so much days that there are certain things we can presume. We'll take it up.
Okay.
Tuesday we'll take it up. Tuesday we can take it up. Okay. Mr. S. Islam, then counsel for the petitioner, submits that there is some urgency in the matter. How the respondents are represented. If a list on, make it Tuesday. Or Thursday. Third, okay, 3/9/2026. Okay. Other matters would be rolled over.